So all of these webinars that I've been doing have been recorded. I'm recording this one as well, so that if there's somebody who wants to see it later, if you want to review it later, I can get it sent out to people, and hopefully it'll be a useful tool. If you have attended any certification training for level 2 in the past, then this will be a review for you, because that's where I'm pitching at. That's the material I've got. If you are looking to get training to be a certified domestic abuse advocate, then this is for you. We'll be going for 2 hours, presumably, or until I run out of steam, or until you get so hungry you say shut up and go away. And it looks like there's just a couple people missing at this point. And I will try not to talk as fast as I have been in the last couple. That's something I need to remind myself, is to just slow down and breathe and take a drink. Okay, so restraining orders. The first thing that I want to pick apart for everybody is just the language. There are so many terms that are tossed out there, and to some extent they mean the same thing, and to some extent they are different. So let's just start with the word restraining order. To me, that's kind of the topmost level term. I see a couple other people signing in. Before I really start talking, let me give them a chance to get their audio going. Couple people have just joined us. Welcome. I'm just doing some introductory stuff. And yeah, I know that the name that's up on my screen at your particular program may not actually be who's participating. That's okay. And if when you're filling out your form to for the certification, just put in that this is, this fulfilled that requirement. That's great. No problem. And maybe in some places there's more than one person listening. That'd be something. Okay, so to start with, there's this whole issue of words. And to me, the term restraining order is the all-inclusive one. Because really, you can get a restraining order with the help of an attorney. You can get a restraining order for just about anything. In other words, if my neighbor and I are having a disagreement, and the neighbor is building the fence, and I feel like they're building on my property line, I could go and ask the court for a restraining order that would tell my neighbor to stop building the fence until such time as we can get it surveyed. So really, in a broad sense, a restraining order is just an order from the court saying, stop doing that. Okay? And then there are different kinds of restraining orders. A protective order, so if you imagine a tree, a restraining order is at the top. Let's split it into two separate sections then. On one side are orders that come out of civil court cases, and on the other side are orders that come out of criminal court cases. So when somebody is charged with a domestic abuse assault, they're going to be, hopefully, given a no-contact order, which is before they are, they're arrested, and before they are released, they have to see a judge. And the vast majority of judges in Iowa will issue a no-contact order before that person is released from jail. So that a no-contact order is something that's attached to an ongoing criminal case. So that's on one side. On the other side, on the civil side, you would have a protection order that would fall under all of those other different terms there. A protection order is an order from a judge saying just that, don't hurt this person, stay away from this person. So it's a kind of restraining order that says those things. Now, the other terms that are on your screen there, in some cases, talk about where that order comes from. So it is the Iowa Code Chapter 236 that has the process that we're going to talk about for a person to go in on their own and get a protective order through the civil court process. And so an order that somebody's gotten from a judge based on the process laid out in 236 is called a 236 order. So a protective order that is a 236 order, it's the same thing. It just tells you that's how they got it. A 598 order, Iowa Code 598, is the part of the code that deals with divorces, or in the code they're called dissolutions. So if you see something that's called a 598 order, you know that that person got that order through going through the dissolution process. Protective order, order for protection, they mean the same thing. They're just reversed order. When you go and you get a 236 order, and a lot of what I'm going to be talking about is a 236 order through that part of our code, you're doing it, you can do it for yourself. You can get an attorney, and we'll talk about some of the reasons why it's important to get an attorney, but you can do it for yourself. And the legal term for doing something on your own for yourself is pro se, for yourself. And so those orders are sometimes called pro se orders. So you can get a pro se protective order. Orders come in two other flavors, and any of them can be a temporary order. A temporary order is an order that's been issued without a chance for the other party to have their say. You've gone in and asked the court for protection, and the court has only heard your side. That would be called an ex parte communication, outside of a hearing, outside of the courtroom. They've only heard your side. Judges will quite often issue a temporary order, kind of a err on the side of caution. Once the other party has had a chance to have a hearing in the court and you've each presented your cases, that's when you get the permanent order, presumably when the judge rules in your favor. So a permanent order, however, is not permanent. A permanent order is usually good for a year. So it's a little tricky language-wise. Okay, I probably just made that all even more confusing, but there's the language. Just try and remember, a no-contact order means there's a criminal case. A 236 order means that it's a civil case. A 598 order, again, it's civil, but it came out of a divorce. First of all, you get your temporary order, and then if you're lucky enough, you can get a permanent order. That orders that are to protect somebody from abuse are called protective orders or orders for protection, and that all of them are some kind of a restraining order, telling somebody to stop doing something. And then I have consent agreement in there too. We'll talk about a consent agreement. Okay, clear as mud. Oh, and look. Kirsten, you need to pay attention to what's coming up on your screen. Okay, so this is what I just said. First thing is to go over that 236 process. Your first step as a victim is to go to the clerk of court in the county where either you or your abuser lives. You can file in either county. The clerk will give you the paperwork, or of course you can contact your local domestic abuse program, who should also have the paperwork handy. You can also download the paperwork off of the ICADVA website. Let me show you. So here's the coalition website, icadva.org, and under resources, if you go into resource library, over here on the side, you'll see this is the petition. This is the application request for it. The temporary order is just a sample blank document of what that would look like, and then this is what the permanent order would look like. As long as we're on this page, if you want, as far as handouts to accompany this, if you scroll down on this page, let's see, where is it? Yeah, oh, that was right at the top. Under Training Manuals for Advocates, click on that, and everything that I'm covering is covered right down here. So you can download that and read that, and it would have all the same stuff. Okay? Alrighty. So however she might get it, she gets a copy of that petition, and she fills it out. It has to be notarized, and then she takes it to the clerk and asks to file it. There is no filing fee. That doesn't necessarily mean that the clerk might not. I think we've pretty much gotten this one conquered. That I haven't heard recently that there are still clerks demanding filing fees, but just in case, so you know, there is no fee to file it, period. A judge takes a look at that petition. Usually the clerk will, hand it off, and the judge takes a look at it. And then it really depends on what flavor of judge you got and what they had for breakfast that morning. Some judges want to actually have that person come into their chambers and get a chance to talk to them, maybe ask them some questions about what's on the petition. A lot of judges anymore want to have that person come into the courtroom and swear them in and have them sit in the witness box, and may ask them questions that are then on the record, and they'll record it. There are some judges who just read over it, and as I said, they just decide, I'm going to err on the side of safety, and they just automatically sign them. So it's going to depend on what that judge, what they traditionally do, how much time they have. Is this being wedged in between two other hearings? Have they got a trial going on? You name it. So she may have to actually get on the stand and testify. She may have to talk to the judge in person, or she may just have the judge sign it and the clerk brings it out, and there you go. Assuming that that is what happens, that the judge reviews it or has her testify, or you name it, and says okay, and goes ahead and issues the order, all well and good. That order then is going to go to the sheriff's office to be served, and she will get a copy of it. If, for whatever reason, the judge says, nope, I'm not going to sign this, nope, you can't have a temporary order, the judge has discretion in issuing the temporary order. The judge does not have discretion in terms of setting a hearing. So even though that temporary order may be denied, the judge is required to set a hearing for about 2 weeks later. So it can be very discouraging for your client if they are turned away at that point. But if they truly want to pursue it, they can say, well, I want my hearing anyway. And then that will give them a chance to actually present a whole lot more evidence to prove to the judge that, in fact, they need that order. As I said, the piece of paper, then the temporary protective order, goes to the sheriff. That sheriff has to be able to find the abuser and give it to them before that piece of paper is any good. So if your victim doesn't know where the abuser is, can't find him, has no clue what to tell the sheriff, there's not a heck of a lot of point to it, because it's no good until it has been officially served. Let me go back and pull up that petition. There's just a couple things I want to say about it. So here's what it looks like. This is the standard form orders. Because the because we had the firearms changes, that we were successful in the legislation this year, yay! All of these orders are currently going to be redone, and it takes a very long time to get even a couple words changed on any of these orders, but do look for some slight changes in the future on all of these forms we're about to go over. I just want to point out that when she's filling this out, she can use your agency as her address. That is a way of trying to provide some kind of confidentiality and protection. She's going to have to fall under one of these different categories in terms of relationship. We do have dating violence, so she can just, dating violence is covered. She can click intimate relationship. One thing that she can't do is go and get this order on the behalf of a, she can't get this order on behalf of a minor child. If I'm 17 and I'm being battered by my boyfriend, I can have my parents come along and help me and fill out this form to protect me. But if I am a mom and I have a 5-year-old that I'm afraid is being abused by the 5-year-old's father, I can't go and go through this process to get a protection order for my 5-year-old to protect him from their dad. Nature of the alleged domestic abuse: physical abuse, sexual abuse, and then there's threats, direct threats to physical safety. If there isn't a direct threat to physical safety, you can pretty much just forget it. Not only do pretty much all judges insist on a direct threat to physical safety, the vast majority of them in Iowa right now want there to have been an actual physical assault, and they want that physical assault to have been in the near past, like within the last year. That doesn't apply to all of them, but the vast majority want to have an assault within the past year to qualify, even though a previous physical assault is not actually necessary. I mean, there is that box there. But if the person is not worried about their physical life and safety, they're just feeling harassed or anything else, they can't do this process. As much detail as possible in the description areas is good. There's a set of questions here about children in common. And just one heads up, if for any reason, let's say that they do have a child in common, but as is sometimes the case, the batterer was not, they have not been married, and the batterer did not want to claim that child because he didn't want to pay child support or whatever else. And so the batterer is not on the birth certificate, is not paying child support. There is no legal document establishing that person as a parent or guardian of the child. She should just run with that. Because if she fills this out and says, oh yeah, we have a child in common, even though he's not identified on the birth certificate as the father, then she's essentially just testified that he has legal rights to the child. If there's nothing legally in writing yet, don't give him that. Let him come in and have to prove paternity first. So I've got a very good question here. Is there a specific set of questions that the victim should ask the abuser during a hearing if the victim does not have an attorney and the abuser does not consent to the order? And the answer to that is no. I don't have a written out checklist or anything. And you can't tell her what she should ask, because that would be the unauthorized practice of law. What you can do is help her plan and safety plan like you would with anything else. Say, okay, first of all, let's talk about the home. Do you feel safe in the home? Do you want to have possession of the home? Would you rather have possession? Would you rather that he, and this is something she can ask for, that he pay maintenance so that you can rent he can assist you in renting someplace else. So you're just kind of throwing out options, and then she would have to kind of make a plan and write down, okay, I want possession of the home, and I want him to be ordered to continue to pay the mortgage while this restraining order is in place. What about, and your question would be, well, what about the kids? Is there a visitation plan that would work for you around the kids? And for her to figure that out and make notes for herself around that. Let's talk about the abuse and have her, what is it that you're afraid is going to have happen? And then she can write that down. Here's what I'm afraid he might do. And what, tell me about the last assault. The judge is going to want to know about previous assaults, so she can think about what exactly she wants to say about that. What she's going to be testifying to is pretty much what she ends up putting on this form. And so if she gets into a debate with him about whether or not he's an abuser, that's probably not going to work. You have to be really careful in terms of helping her prep. You can ask her general questions. What is it that you want to have say? What is it that you want to have happen? And help her come up with some questions, but you can't give her a list of questions or tell her what to say, because then you're acting as an attorney. And this is a very fine line that you have to walk. And it's going to be very specific to her individual situation. Maybe they have a business in common that they both own a store. So, for that woman, she would need to be able to make that point about what she wants. If there's kids, it's going to be specific around the kids. If she's an immigrant woman, maybe she wants help with documentation. Maybe she wants him to give over her passport. So it's going to be very specific to that individual woman. Okay. So she has to ask the judge to do both kinds of orders, the temporary one, the emergency one, and then what she wants on a permanent one. You'll note that, to the extent that she can ask questions or say what it is that she wants, this is kind of her place to begin outlining that. Of course, to stop the abuse. Of course, stay away from the home or the family home. Stay away from her work or her school. No contact. And then you get this temporary possession stuff. Does she want the family home or not? Does she want one of the cars or not? What does she want around custody? Does she want temporary support or not? Is there anything else that she needs? Her economic safety may be key to her physical safety. Is there anything else that she needs from this hearing? Put it in there. Put it in there now. I have heard immigration attorneys say that they have been successful in getting orders where the person simply requests the stop domestic abuse, but not request that the person stay away. In other words, they're still living in the home, but there's a judge's order saying quit the domestic abuse. That they've been successful with that in cases where you have an undocumented batterer who is essentially so intimidated or so highly motivated to avoid the eye of the court, that just doing that is enough to make them at least stop the abuse, stop the physical assaults, because they don't want to be arrested and be deported. So, but honestly, that's the only situation I can think of where you would check the first box and then not keep checking other things. I would suggest that you go over this last page with her as well. She needs to know that there is going to be a court hearing and that the abuser is going to has the right to be at that hearing, and that she has to be at that hearing, and she can't just do this to do like a 2-week break and then say, well, I've changed my mind, I'm not going to show up at the hearing, and the matter will be dropped, because that will essentially poison the court towards hearing her in the future. This section is around confidentiality. Without being checked, her petition is public record. Here's a comment, very useful, from Aaron. I always tell my clients that they should bring last year's taxes so the judge can do temporary child support at the hearing. Yeah, you know, if she has documentation already, pictures of her injuries, tax information, maybe she thinks that he is going to argue about paternity and not want to pay child support. It's anything that she could have, just that she will be presenting at her permanent hearing that she may already have, photocopy it and attach it to her temporary. Why not? It'll just bolster her chances there. Around the confidentiality, these are open records unless she specifically requests otherwise. So she'll need to check these boxes. And one thing that she needs to know is that the batterer, even though she may have checked that this is confidential, the batterer gets to read this petition. So everything she's writing on it, he will read and be able to address. So it's not just the judge that she's talking to when she fills this form out. Okay, we'll go back to this. Okay. Let's talk about matters of proof. Tax records is a great one. Her testimony, of course, is proof. So she shouldn't despair if she has nothing to offer except just telling her story. Her testimony is proof, and the judge is going to be looking at believability, credibility. Do the stories match? Does it seem like somebody is skirting the issue? Do their stories fit together, or does somebody seem to be lying? If there's witnesses that can come, maybe somebody has heard the abuse, maybe a coworker has seen injuries on her, you name it. So she could bring witnesses, medical reports, police reports, photos, recordings of phone calls. It is legal in Iowa to record a phone call so long as one party to the call, or conversation for that matter, is aware that it's being recorded. If neither one of them, if they're on a phone call and neither one of them knows that it's being recorded, that's not submittable evidence. But if she knows that she's recording, or that she's got a little, pocket recorder at the custody exchange, and she hit the record button before she got out of her car, and it's in her purse, that's fine. That is evidence that can be submitted. Here's some things that may be hurdles in terms of getting a protection order. She's got to have transportation to get to and from the courthouse, and that can be a hurdle. Particularly if she needs it now and the judge is only in this particular county on Wednesdays to hear orders, she may have to find a way to get to a neighboring county. Or in some cases, it could be faxed over to the closest available judge. But for the hearing and everything else, she's going to need transportation, and she's probably also going to need child care. She has to have a picture ID. She can't get anything notarized without a picture ID. She's got to prove who she is somehow. I said she has to know where the abuser is, and she has to be willing to face him or her at the permanent hearing. The abuser gets a copy of everything she writes down, so she may want the order, but if she's unwilling to say it directly to the abuser, that's going to be a problem. To file for the thing is free, but if she has a witness that has to be subpoenaed, she's probably going to have to pay to have that person subpoenaed. Here's another good question. What do you do for clients who can't afford an attorney and legal aid will not help them? The answer is they either have to do it pro se by themselves, or you beg and borrow whatever local attorney to do it for free, or to do it for a reduced cost. Maybe once in a while, once in a very long while, you do run across a client who can pay. And so if you direct paying clients, when you get them once in a while, to either somebody who has done stuff pro bono for free for you, that can help build up that relationship where, okay, if you've done these 3 for free, we'll send our next paying one to you. Or you did this paying one, now, we sent that person to you, now would you please do a pro bono one for us? There really is no other alternative. I mean, you can call, some of the law schools have legal clinics that can assist in preparing her paperwork. So she may be able to go to, to Drake Legal Clinic and see if she can get some help with it. Presumably, this is the reason why they made it so you could do it pro se. But I know, particularly in the cases of kids, that's not terribly helpful. Where it says if she has kids, she must have an attorney, that's not a legal requirement. That is once there's kids involved, it just makes the legal stuff around it much more difficult, and it's very hard to navigate without any kind of legal information or experience. So it's not that she legally has to have an attorney, it's that it will be extremely difficult for her to do it on her own. If for whatever reason she does not want to abide by the order, in other words, she wants him to be told to stay away from her and from the house, but she would be okay calling him or catching a ride with him or going over to his house. If she doesn't want to act as though the order is just as much against her, she shouldn't get the order. If she won't be at the permanent hearing, she shouldn't get it. There may be times where she has decided that this is just going to escalate him, then don't bother getting it. And she's the best judge of whether this order is going to help or prevent her safety. You can get orders on an emergency basis. Let's say it is, well, I'll give an example of one that I did. A woman came home and she had left her 14-year-old and the baby in the apartment. And when she came home, the 14-year-old said that the baby's father, the abuser, had been there. They had different fathers. The baby's father had been there and had taken the baby. And this client was absolutely sure that he would be fleeing the state. Now, here's the tricky thing. I then helped her to go get an order that wasn't appropriate. In other words, you can't, what I just said, that you can't go and get an order to protect an infant, that is essentially what we went and did. So I went with her to the police station and we told them that we needed to see a judge immediately. We needed an emergency protection order. And we got one of our district court judges out of bed. I think he came down to the police station in his pajamas under his raincoat. And we had filled out the paperwork while we were waiting for him. If he wasn't willing to come down there, if he was in another county or whatever, you could fax the petitions to people. And he questioned her repeatedly to get her to say that she personally was afraid of being assaulted to get this order. But as a piece of the order was giving her temporary custody of that infant. Finally, she did, in fact, say what the judge needed to hear. He signed it, and the police immediately went and served the guy and picked up the baby and brought it back to her as he was leaving. He'd had the truck loaded, and he was, in fact, preparing to leave the state with the infant. Okay, that's not how you're supposed to get restraining orders, but it was an example of when an emergency order worked. Those orders are supposed to be good for 72 hours. The idea is that maybe you need to get one on a Saturday, and the 72 hours is to get you back to a business day where you can where things can be done as usual. Okay. When she gets an order, she needs to keep it with her at all times. Everywhere she goes, she needs to carry it with her. And if she moves, I'll talk about full faith and credit. Technically, legally, she should just be able to go wherever she wants in the country, and she should be protected by it. But if she's going to be spending any significant time anywhere, if she's moving, is it to her advantage to take that in person to her county clerk's office and to whatever local law enforcement, sheriff, whatever, and give them copies personally, just to kind of cover her butt. Alrighty. I'm going to take a swig here. And we'll talk about enforcement. I wish I had something brilliant to say about enforcement. I think enforcement is where we fall down. You can get the order, but getting it enforced is a whole nother deal. So you've got a protection order, and your batter is standing on your front porch pounding at the door. You call 911. Very similar to an assault, the police have to have probable cause that an assault occurred. They have to have probable cause that the order was violated. So if they show up and he's long gone by then and there's no evidence he was ever there, there's a lot of officers who will say, I don't have probable cause. All I've got is you saying that this person did this thing. I have no evidence, no proof, and they will walk away. Now, you may have some officers who will say, hey, I've got a 911 call, and based on excited utterance or whatever else, that's probable cause for me. I will make the arrest based on that. If they do have probable cause, let's say a neighbor saw the car sitting there in the driveway and came over and immediately told the officer, no, he was here. So there's witnesses, something like that. If they do have probable cause, they are to immediately take that person into custody if they can find them. If they can't take them into custody, then they can go and get an arrest warrant to take them into custody. As far as what happens next, violations of protection orders can be prosecuted two ways in Iowa, either as a simple misdemeanor or as contempt of court, but you can't do both. And this varies county to county. In some places, the prosecutors themselves will file it as a criminal charge, a simple misdemeanor. In some cases, the prosecutors themselves will file it as a contempt of court. And in some cases, the prosecutor says, hey, not my problem, talk to your attorney. And she's either got to talk to her attorney or on her own, she has to go file a contempt of court charge against the person for the violation. One thing about filing it as a contempt is that the person could be charged with contempt and something else. In other words, the only criminal charge that could arise out of it, if you're going to charge the violation of a restraining order as a simple misdemeanor, then that is the criminal charge you're filing for that incident. But what you could do instead is file a contempt, a civil contempt charge, and then criminally file if what the violation was is that he reassaulted her or that he broke into her house again. That can be filed as a separate, totally new criminal charge, and then you can also file contempt of court civilly against the person. I hope that makes sense. If it's the sentences, it depends on if it's civil or criminal. So if it's a contempt of court, the person can get 7 days in jail. Misdemeanors, there's a minimum of 2 days in jail if you're found guilty of the misdemeanor criminal charge. Okay, I mentioned before that a permanent order, a permanent 236 order, is good for 1 year, which is very confusing language because you can actually get a permanent 598 order, one that's arising out of a dissolution, of a divorce, that is actually permanent. You can get a permanent 598 order, which is good for the rest of your life. But a permanent 236 order is good for a year, and you have to file before it's expired to have it extended. If you miss that deadline, you have to start all over from scratch, as though it never existed, and you have to prove everything from scratch. Now, the funky thing about these is that if you have a protection order and it has been working for you, the batterer has stayed away, you have been safe, and you go to the court and say, hey, this is really great, this has been working for me, I haven't been reassaulted, I've been safe all year, please extend it for another year, the court will say, but there's no more imminent threat to you. It worked. And then, so you're not, if it's working, you're not eligible to get it renewed. I'll just say that one more time. If it's working, there's no more imminent threat, and therefore, you're not eligible to have it renewed. If it's not working, if the batterer is continuing to threaten and harass you and stalk you and assault you and everything else, so that you still have an imminent threat, if the protection order sucks and it doesn't work for you, then you can have it renewed for another year. Doesn't that make sense? I thought so. Let's say that it's not working for her and it just seems to be escalating things. She's getting a lot of pressure. Or let's say it's not working because it's more hassle than it's worth. She needs him to transport the kids to school. She needs, she misses him. The kids are driving her crazy, harassing her because she's being bad, throwing him out of the house, you name it. If for whatever reason she wants to change it, she needs to go to the clerk's office and get, and it's another form that she asks in order to either modify the order or to drop the order. So let's say that the visitation arrangements aren't working. She could go in and just ask to modify that piece of it. Or she can go in and ask for the whole thing to disappear. Alrighty, I mentioned that technically, legally, no matter where she goes in the country, she should be good to go once she has that permanent order. And this is the permanent order. It's not the temporary order. There has to have been a hearing where both parties had the opportunity to present their case. Once she has that permanent order, supposedly, no matter where she goes, just like a driver's license, it's supposed to be valid. So if I am pulled over in Mississippi, I show my driver's license and they just assume, okay, you're valid to drive. I should be able to whip out my restraining order and they'll go, okay, we'll enforce it. If on the surface of it, it looks valid. There are federal crimes as far as crossing state lines. Interstate travel to commit domestic violence is a federal charge. Interstate stalking, crossing state lines to stalk, is a charge. And there's a whole separate charge if you travel across state in order to violate a protection order. You can be charged in federal court as well as in the state court for that crime. Again, federal firearm laws apply to the permanent order, not the temporary one. Had to have had that hearing. Big thing about can't take away people's guns without having them had their time in court, without having due process. But when you've had the hearing, they've had their due process. They were heard in front of a judge. And that's when the federal firearms stuff kicks in. So it is a crime to possess a firearm while you are the subject of a protection order. And as you know, it's also a crime if you have been convicted of domestic violence. It's also a crime to transfer a firearm to somebody who is the subject of a protection order. So if my batterer has a restraining order against him and his brother gives him a shotgun, knowing that there's a protection order in place, then not only could my batterer be charged with a federal crime, but his brother could be charged with a federal crime for giving him that that firearm. And we have now had this for enough time to know that having the firearms removed as a result of protection orders does have an impact on our intimate partner homicide rates. They have gone down. So taking the guns away does prevent firearm deaths. Okay. Well, if we were doing this in a live form, I do a little game here of pros and cons, but maybe you can think of some other ones too and send them in the chat question box. Excuse me. Here's some pros that I can think of as far as restraining orders. One is that, hey, it might actually restrain, particularly if you have a batterer who is pro-social, who is invested in their community, who doesn't want public scrutiny, who wants to maintain a positive reputation in their community. They may act better when they feel like they're being watched. And it may, you're not perhaps changing their beliefs or what they think they have the right to do, but at least while they are being scrutinized by the court, they walk the line a little better and their partner feels safer. Another thing that might be helpful is if you look at our stalking language, there are a couple things that you have to prove in order to prove a stalking case. And these are some things that make prosecutors very uncomfortable. They're often the reason why prosecutors don't want to charge stalking and would rather charge other things. In order to prove stalking, you have to show that that defendant knew that what they were doing was unwanted and that they knew that their actions were putting that victim in fear. And anytime you have to prove not what somebody did, but what was in their head, that's an extra hurdle for a prosecutor. So that's one of the things that makes the stalking cases more difficult. But when you think about it, if somebody has been given a protection order, then a judge told them that their behavior was unwanted, and a judge told them that they were putting somebody in fear. And so that essentially proves the elements of those hard elements of a stalking case. So a protection order could help in building a stalking case a little bit further down the road. If you can prove that somebody had violated a protection order, then you have all of the elements to prove a stalking case. So it may be a step towards those charges. There is the fact that you do have full faith and credit, so it is transportable, and we know that so many clients find that they really can't stay in their community any longer, and they have to relocate. So having some kind of transportable safety is a nice thing. The firearm prohibition is good, saves lives, and the fact that we have the pro se process is helpful because it provides access to the court systems that is free or at least low cost. Now, does anybody have any other things where you found that pro se orders are just fabulous for? I'm going to keep yapping. It does help to establish the record. It might be useful later on in a dissolution to look back and say, oh, and this person applied for a restraining order 3 years ago. It does have the provisions in it for child support, spousal support. It does have the little checkbox there where you can say, hey, I need our tax records. Hey, I need my passport. Hey, I need whatever. And the other thing is that this, a protection order supersedes other custody orders. In other words, perhaps they've already been to court and gotten a hearing around child custody and visitation, and there's already judge's orders in place around that. And mom goes in and gets a protection order, and what she asks for in terms of visitation, perhaps she says, no more visitation. The pro se order, the permanent order, supersedes any previous court order. Now, when it's up, it would, when that year is up, everything would go back to that previous order. But at least while it's in place, that's a good thing. Good question. Does custody through a no-contact order trump custody and visitation set up through DHS or juvenile court? And the answer is yes. That it trumps everything. Because, if you think about the purpose of it, is that it's supposed to be essentially a short-term safety issue in an emergency. Then yes. There may have been a previous juvenile court hearing. There may be stuff that's been arranged through a counselor or you name it, DHS. But what we're saying is now there is this new imminent danger, this new imminent threat. And in order to achieve safety, we're going to do this for now. And that's why even the permanent order is temporary. Now, one of the problems, we can move to cons, is that since these orders do include stuff around custody, stuff around possession of the home, possession of a car, you name it, judges are becoming, have been, and are becoming even more leery of ordering any of those other things. In other words, more and more orders are coming out where the judge says, okay, you have to stay away from your partner, but they're refusing to do anything around the child stuff, or they're refusing to do anything around the other requests, because what they're saying is, you're abusing this system, you're using this system to get a quick mini divorce. You're circumventing the divorce process and trying to get a leg up on it. And there are attorneys that are advising their clients to do this actually as a strategy in terms of getting a leg up. And so judges are becoming more and more suspicious and leery of other requests included in restraining orders. So that is definitely one of the cons, is they essentially are gaining a bad reputation. Another con, and I will rant and rave, I guess, not go into it, but rant and rave at length about the idea that if she violates the order, which legally is an impossibility, because the court has no jurisdiction to order the victim to do something. Anyway, if she, quote, violates, unquote, her own order, she may get charged with aiding and abetting in the protection of the order. Another con is that it's worthless unless it's enforced. And depending on who she is and where she is, enforcement may be very difficult. She may just live someplace where local law enforcement says, hey, it's a civil order, have your attorney deal with it, it's a civil matter, we don't have anything to do with it. Go talk to your attorney, go talk to the prosecutor. Or she may be in a community that has a different attitude in general, but she personally has a bad relationship with law enforcement, where she's seen as being, she's worked in prostitution, she's got a criminal record, you name it, and they just don't give a rat's butt, and they're not willing to help to enforce it. They figure out she's just as bad as he is, or she's trying to set him up, you name it. Okay. I talked about them needing probable cause in order to do the immediate arrest. Very likely, even though she may be protected, very likely it's going to have provisions to still exchange the kids. And so even though the focus may have been largely on her being the target of the abuse, when now the children are the only avenue and access that batterer has, the focus may shift to the children, either to punish her, to threaten her, to coerce her, you name it, or to get her to drop the order. So the kids are still likely to be exchanged, and the kids' risks are likely to escalate. It may be an avenue for him learning where she is. You know, if she files it in a county that she's moved to, she's fled to Sioux City and she's staying at the shelter there, and she files it there. Now he knows, oh, she's living in Sioux City or in that area. Children are not eligible on their own to apply for one. Teens, if I'm being battered by my boyfriend or by my girlfriend, my parent has to go and apply. And I can remember a case where mom said, "You made your bed, you lie in it. What else? What else did you expect, you little slut?" So that wasn't very helpful. We've talked about the issue of getting an attorney and the struggles there. That's nothing new. This is a way that the batterer can establish paternity if she writes it down there. If there's no other legal documentation, then she's just helped him to establish legal parental rights over those kids. Another thing that's kind of a funky loophole is that while it is illegal to violate a protection order, it is not illegal to attempt to violate a protection order. So if the abuser goes to her house and she's not there, he didn't actually violate the order. So that may not feel terribly safe sometimes. There has been some research on how successful restraining orders are, and it's very controversial. It does seem to, overall, it seems to improve safety, though not overall for everybody. You're more likely to have your restraining order violated if it's a short-term relationship, which I thought was interesting because I would have suspected that if I'd been with my partner for 10 years or 15 years, whatever, that they would be more invested in getting to me no matter what. But in fact, it is short-term relationships that have the greater risk of violation. Go figure. Lower income people are more likely to have their orders violated. If there's children in common, and that doesn't surprise me at all, more likely to have the violation there. Temporary orders are violated a whole lot more often than the permanent orders, and African American women are more likely to have their orders violated. Batterers, again, who are pro-social, who are engaged, who have a reputation to preserve, are less likely to violate. Here's something funny. If they've been arrested previously, they're actually less likely to violate. I guess at some level, for many of them, they've figured out that actually the cops will arrest them and will take it seriously, and so therefore the batterer takes it more seriously too. Yeah, and no children, less likely to violate. I think the odds are a bit lowered without having that right to my children piece into the equation. White and Hispanic women are better protected by these orders and less likely to violate if it's a long-term relationship. I already mentioned stalking, that if you can prove a restraining order violation, you've proved a lot of the elements of stalking. And this is one of my little hobby horses, is that violations of protection orders are stalking. And we need to start thinking of them in that way, because when we start thinking of them in that way, we take them more seriously. What you've got is a perp who's been told by the victim, hey, stay away from me, I don't want anything more to do with you, you're scaring me. Who's been told this by the police, and who's been told this by the courts, and they don't give a rat's butt. So what you've got is a batterer who's refusing to have anybody limit their behavior. That automatically bumps them up into a higher risk category. You have a pattern of behavior. They've had to have done it before in order for the person to get the restraining order in the first place, and now they are violating that order. So you're showing an ongoing pattern. This is a more risky batterer, and so it's not surprising that when we look at intimate partner homicides, we see very high rates of stalking. Stalkers are not willing to be told no by anybody. So it's not surprising that when somebody is stalked, they're also very likely to be assaulted by that person. Much more likely to be sexually assaulted by an intimate partner who is stalking you, who is continuing to violate the restraining order, than one who does not do those things. And very high percentage of stalking preceding homicides. The Iowa Death Review team met was it just last Friday? Well, no, Friday before that. And all of the cases actually that we reviewed had prior heavy major stalking going on. In one case, the guy took her son and sat outside of her boyfriend's house with her son for hours in the car watching the house. So he was even engaging the children in his stalking behavior. That's somebody who's not willing to be told no. Okay. Moving right along, let's talk about your role as an advocate. So in Iowa, we have a few things to our advantage when we are helping people with restraining orders. Here's one of those things, Court Rule 37.4. This is the thing that gives us the right to distribute forms and assist people with the pro se process. That means that we can tell people how it works. Here's what you do. This is step 1, and this is step 2, then this is step 3. We can give them the forms, hand them out, and we can explain what those questions mean. Kind of interpret the legalese in some ways. When they're asking for this, that word means this. We can be with them through all stages of the proceedings. In other words, let's say that she did file for the temporary order and the judge wants her to come and speak to her in chambers. You get to go in and sit there with your client in judge's chambers while the judge interviews her. And we get to sit before the bar. This is where you go, ooh, ah. The bar being that little fence in the courtroom that separates the audience from where all of the actors are. And you get to sit at the counsel table with victims during the 236 proceedings. What you can't do is give legal advice. You can't say, here's what you need to write on this petition. Here's what you need to ask your abuser when they're on the stand. And this is why I said I can't give a specific list of questions, because that would be giving legal advice. You can't yourself ask the questions of the witnesses. And essentially, it's you speak when spoken to. In other words, if the court asks you a question, if the judge asks you a direct question, of course you can answer and you should answer the judge. But you cannot directly address the judge. If you just think of it that way, I really cannot directly address the judge during a hearing. My client could. Like I could write a note to my client and say, did you want to ask, or remember that you wanted to ask the judge if, and remind them. I can do things like that, but they need to speak directly to the court. And I can't represent them. So let's say that the batter has an attorney, and the batterer wants to, and my client is representing herself, and the batterer's attorney wants to talk to her about possession of the truck, right? And she says, I'm too scared, would you please talk to him for me? I can't do that. That would be representing her. She has to talk to that attorney on her own if she's representing herself. If I do any of those things, it is called the unauthorized practice of law. And that would be a bad thing. You can be charged with that, and you can go to jail for a couple of days for the unauthorized practice of law. So you can't represent someone, you can't give legal advice, and you cannot prepare a legal instrument. So you can help them fill out the form, but you cannot prepare it and submit it for them. So let's pick that apart a little bit more, and now I'm going to use a nifty webinar fun thing. Here's another good question. Are we allowed to speak up in mediation, in a mediation setting with abuser's attorney if we feel the attorney is trying to coerce the victim? Yes, you can, because that is not a legal, it's not a court hearing. It's not a hearing. So there you are advocating for the person. You're not representing them as their attorney. So mediation is a different setting. Just like you could speak up if, let's say that you and your client are talking to her landlord. You can, or her child protective services worker. You can speak up and say, you know, it seems to me right now that you're really pushing, you're really pushing my client, and she's stated pretty clearly what her position is, and can we have that in writing, or those kinds of things. Absolutely, those are not legal hearings, and so you're not being an attorney, you're being an advocate there. This is why I say it's very it's an interesting way to walk, and in some cases it's even just a matter of what words you use. So I'm opening a poll. Hurrah! And I'm trying to think if I've even used these before in a webinar. So here's my first question. Is it the unauthorized practice of law to, oh good, you can see it but I can't, to whatever the question there is. Let's see if I can pop it up for myself. There's got to be some way. Is the unauthorized practice of law to have your client wait in the hall while you talk to the judge for her? I'll give you a moment to answer. Okay, so it's not as much fun as a Cosmo quiz, but got to make it interactive somehow. Most of you have voted, and the answer is yeah, it is the unauthorized practice of law. Again, you would be representing that person. Now, if you want to talk to the judge about court process, like, Judge, is this what we do next? Or, Judge, to remind the judge that even though the judge has turned down the temporary, they still have to set a permanent. That's not representing the client. So you could talk to the judge in those ways, but to say, hey, Judge, this is what she wants, or this is, to speak for her, that is an unauthorized practice of law. So we will close that one. How about this one? Is it unauthorized practice of law to fill out a petition for a woman who can't read or write? I'm seeing more of a split in the vote there. And yeah, this, again, this is a narrow one. And the answer is no. You can fill out a petition for somebody who can't read or write, in the same way that an interpreter could translate what that person is saying into English and put it down. What you need to do essentially is take dictation. If you take dictation and you fill that out, not she said, but I, in her actual words, and then mark on it that it was transcribed by you or dictated, and just write that in at the bottom, sign it. That's perfectly okay. So. If she can't read or write, or English is not her first language, or whatever else, you can essentially take dictation and to assist her in filling out those forms. That's one of the things that we are authorized to do. Oops. Oh, there's a button I need to push so that you can see the results. Wow. Here's another one. Can you write a letter on her behalf? Is it the unauthorized practice of law to write a letter on her behalf to the opposing attorney regarding visitation arrangements? Is it the unauthorized practice of law? And I'm trying to avoid double negatives here. Is it the unauthorized practice of law to write a letter on her behalf to the opposing attorney? And yeah, it is unauthorized practice of law. Again, whether you're doing it in person speaking or whether you're writing a letter on her behalf, you're essentially representing her, and you can't represent her. Now, let's say she doesn't know how to read or write. English is not her first language, or she doesn't know how to use Microsoft Word or whatever. You can take dictation again. You can take dictation, have her say it, you write it up. She signs that it's, that it is her words. You can do that. That is assisting without representing. Let's see. Let's do a couple. Let's do one more. How about this one? Is it the unauthorized practice of law to tell her that the judge usually likes to know details of the last physical assault?
Owners at Derby, and then you keep scrolling down, and it says it's on the place, and it says no one gets like Bobo's Aaron Kiernan, safety board, and
Well, so far, everybody's pretty uniform on this one. And you're right. No, that is perfectly acceptable. Because, again, you can say how things usually go. You can talk about the process. If you say you need to write down that you need to put the details here of the last physical assault, or this isn't detailed enough, you need to, you're getting awful close to the line. If you say, in my experience with this judge very much wants to know about fear, or this judge very much wants to know about what's happened in the last year and doesn't tend to care about anything that's happened before that. In my experience, you're just describing, you're not saying what to do. So that's just giving information. So ask yourself, am I telling her what to do, or am I giving her information? And so long as you can say, yep, I'm just giving information, you're good to go. It's also helpful when you're doing this to make sure that you tell the person that you're not an attorney and you can't give them legal advice, and all you can do is tell her how things usually work and just provide that role for her. Okay, ta-da, ta-da. Moving right along, mutual orders. I don't think I've mentioned these at all yet. Consent agreements, mutual orders. A mutual order is, let's say that I have filed a petition against my abuser, and at the hearing, the abuser says, well, she's just as bad as I am, and I want an order to tell her to stay away. If both parties end up with an order, that's called a mutual order. Mutual orders are very difficult to enforce. When the police show up, who are they supposed to arrest? It's even more he said, she said. Both are not credible because they both have protection orders against them. So if you think that a regular protection order is hard to enforce, a mutual order is almost worthless in terms of enforcement. They've been shown to be completely ineffective at reducing violence, and one of the reasons is because you have a judge telling the abuser, oh yeah, this victim is just as bad, and I'm going to put an order against them as well, and so the process essentially confirms and adds credibility to that batter's belief system that the victim is the problem. And it makes it even easier for that abuser to have the victim arrested. And, hey, I'm willing to run the risk of getting arrested if I can make sure that whatever, my victim can be arrested too. Mutual orders are quite often not entitled to full faith and credit. If the mutual order was obtained, let's say that there was a hearing, and then at the hearing we each presented our case and the judge said, fine, whatever, I'm just going to give an order to each of you, that order is not entitled to full faith and credit. They only get full faith and credit if the batterer went through the exact same process of filing an initial petition and the judge made specific findings that yes, in fact, the victim had committed domestic abuse. So it's like having that order, they have to have gone through the exact same process in order for it to get full faith and credit on a mutual order.
Oh, does the office something? I can forward you all the information. Okay.
Oh, the quick poll screen is still up. Hang on. Well, it shouldn't be. I've hidden it, so hopefully it's gone. I am talking about, I hope people can see the PowerPoint. I have moved on from the polls. I am talking about mutual orders. So a mutual order is when each of them have been given a restraining order against the other one. A mutual order could be a consent order or it could not. What a consent order is, when people say a consent order or a consent decree, one of the reasons that people like that's a little bit different. One of the reasons that batterers like that is that a judge can enter a consent agreement even with no finding of domestic violence. In other words, to get the other restraining orders that we've been talking about so far, one of the first things that has to happen is that the judge has to declare that domestic violence has in fact occurred. Well, there are often times when batterers are not willing to admit to that, and So what will happen is the batterer will say, I'm not going to admit that there's domestic violence. But what I will do is I will agree, I will consent to an agreement where I will just stay away from the person and will avoid that whole hearing, that whole messy finding of domestic violence, and it'll be quick and easy, and we'll just say, you know, we're going to stay away from each other. So that's what a consent agreement is. There's no finding of domestic violence. The attorneys involved and the judges often like it because they see it as an easy fix. That okay, there's no hostility, we don't have to go through the trouble of having a hearing or presenting evidence. You're both just going to agree, you're going to consent that you're going to stay away from each other, right? Has the same problem in that it reinforces the battered belief that the victim is the problem. The victim is just as much to blame. The victim may very much need that finding of domestic violence for, let's say, an immigration case in the future, for a custody case in the future. Consent agreements don't kick in the firearms stuff. So, I'm going to put everybody on hold for just a second because I'm getting a call from my kid's school and I sent her to school sick, so hang on. Me 2 more seconds. I'm going to call to have somebody go and pick my daughter up at the school so she can come home sick. Hang on. Okay, taken care of. Life doesn't stop just because you're doing training. So I apologize, but I left my phone on for that very reason. I knew that was a possibility. And I see other people are still looking at the polls as well. Okay, well, let me mess with that as I talk to try and make sure that everyone's seeing the PowerPoint. Consent orders are not enforceable in every state. Consent agreements just are not helpful. Everyone but the victim pushes for them, but they don't fall under those federal criteria for full faith and credit. They don't fall under VAWA because there's no finding of domestic violence. They are essentially not domestic violence cases. They're not domestic violence orders. So so they're easy for everybody else. They don't work for the victim. Now let me see if I can get this. There we go. Get that off of the screen. Hopefully that gets it off the screen for you too. I got it off of my screen.
Well, there's a couple different ways, and one of it is, like I said, it's a big supporting member. That doesn't really, it supports them, I thought so. But as far as membership goes, or membership, one of the first criteria is that we.
And Tina, you are unmuted. Did you want to ask something or say something to everybody? You raised your hand. We should all be able to hear you now. PowerPoint's back up for everybody. Okay, great. Thank you with that. Thanks for letting me know it wasn't up. As I said, I haven't used polls before, so a little learning experience for me. And you know what's really great is that I've almost got this whole system of webinars figured out now, and we're switching this month to a new provider, and I'm sure it'll have a whole different control panel, a whole different way of running it. But there you go, always learning. Okay. Another problem with protection orders, and that is if you have a situation, let's say a state, let's say, Iowa. Let's say you have a situation like Iowa where it's possible for a victim to be charged with the same order that was issued to protect her. It essentially has the same effect as having a mutual order where they each have an order against them. And yet that respondent, that batterer, never had to meet the legal requirements to get a mutual order. So that's another reason why the fact that we have this wonderful charging of victims with aiding and abetting sucks. That essentially it gives the batterer a protection order against the victim without him ever having to go through the same struggle and legal process that she did in order to get the order. We are, in fact, the only state in which charging a victim with aiding and abetting is explicitly allowed by our Supreme Court. And this is the case that did it, Henley versus the Iowa District Court of Emmett County. Essentially what happened was the woman had a restraining order against her batterer. He came over to the house. I can't tell you the details of if he was trying to break in or just standing there or whatever else. But anyway, she let him into the home. When the police arrived, she denied that he was there, and they later found him hiding in her house. I think he was under the bed, but don't quote me on that. And he was arrested for violating the restraining order, and she was arrested for aiding and abetting in the violation of the order issued to protect her. And it went all the way to the Supreme Court. And what the Supreme Court decision says, and you can download this and read it for yourself if you can't sleep some night and need to snooze. What it says essentially is that the state of Iowa will protect the victims even when victims are not willing to protect themselves, and that the way that we'll do that is by arresting them. Damn it! It's a very interesting legal argument. In Illinois, they've gone so far as to saying in their statute that you cannot be charged with aiding and abetting, that you cannot hold the victim accountable for the conduct of another person when they are the victim of the offense that was committed. In Minnesota, it says that they have clarified that you can't be aiding and abetting in the violation of your protection order when you let the person into your dwelling. So kind of faced with a Henley situation, they said, well, that's crazy to charge the victim to. So a couple states have gone so far as to pass legislation. But we live in Iowa, so there you go. I wanted to bring up a couple more of our court cases that influence how restraining orders work here in Iowa. And one of those cases is Parrott versus Parrott, which sounds like a Monty Python skit to me. But anyway, in the case of Parrott versus Parrott, there was the woman asked for a restraining order, but it was denied to her based on the fact that she had not previously been physically assaulted. In other words, she was going in and saying, I'm scared, he's been threatening me, there's an imminent risk to me, but he has not previously physically assaulted me. Please give me a restraining order. And the judge denied it based on no previous physical assault. And the Court of Appeals overturned that and said, yes, in fact, you can get a restraining order even if you have not been physically assaulted. You can get a restraining order based on the imminent threat of physical assault. So yes, that is legally possible in Iowa. It's in the code that it's legally possible. We have appeals case is saying it's legally possible. However, it is still very difficult. In other words, most judges still don't want to grant it. And if you are worried about that, then you need to probably bring up Parrott versus Parrott in that case. I will say in that actual case, while he had never, quote, physically assaulted her, unquote, he had pushed her, which counts as physical assault to me. He had chased her to a car. He had punched and broken her car window in an effort to drag her out of the car through the window. But he hadn't actually, physically assaulted her or nothing. And so the judge had denied the restraining order. So there was some fairly egregious behavior that had occurred that I think easily gets over the hump there of no physical assault. But nevertheless, we have that language and we can run with it. Barch, I don't know how you pronounce that, Barch versus Barch. In this case, it was a woman who lived in one of the border counties, I think. Yeah, I think it was between Iowa and Nebraska. I'm almost sure it was between Iowa and Nebraska. I think she was in Council Bluffs. Anyway, and she got a protection order in Iowa, but her batterer lived across the river in Nebraska. And so what he argued was that because he was not an Iowa resident, the state of Iowa had no legal jurisdiction over him to issue a protective order against him. And the state of Iowa said, oh, yes, we do. That, she was a resident here and that we did have the right to enter a protective order against a resident of another state. So there you go. So for all of you who are working with clients living in or from border counties, Iowa says, yep, we can issue those orders anyway. Krischke versus the Iowa District Court of Scott County. This is an interesting case where batterer, after the restraining order hearing, follows victim, in which an order was placed against him, follows victim to the clerk's office, hangs around. She's scared. She won't leave the clerk's office until he goes. He leaves briefly, but he returns with a video camera. Eventually, the clerk calls for a sheriff's deputy to come and escort the victim out of the courthouse to her car, and batterer videotapes the entire event. He was then arrested and charged with violating the restraining order. Now, he claimed that first of all, the clerk's office was a public place and that he had business reasons why he had to access it. And second, the usual, well, she's such a bitch, she's always setting me up and getting this order against me, and I needed to prove that I am making no attempt to approach her or contact her or speak to her in any way. So I got the camera to prove that I wasn't doing any of that. And he lost, and the judge basically said, anybody would find it intimidating to be videotaped like that, much less somebody who had just gotten a restraining order against you a couple minutes ago. Yeah, you have the right to access the clerk's office, but here's the hours of the clerk's office, lots of time. You could do it any time. You don't have to do it when the victim is present. And plus, if you had the ability to leave the courthouse to go to your car to get the video camera, you darn well had the ability to leave the courthouse, go to your car, and go away until such time as the victim was no longer present. So there's some good stuff there about public places and who has to leave public places, and there's good stuff there about even maintaining visual proximity in a public place as being harassment and not being okay when you are subject to a protection order. One more case that I wanted to bring up. We don't have a decision yet, but ICADVA recently filed an amicus brief with legal aid on this particular case. This victim had gotten a protection order, a temporary order, in which she asked for temporary possession of the car because she needed to transport their disabled son to and from medical treatment. And she got, in the temporary order, she got the temporary possession of the car. And then the batterer went and sold the car, which was only in his name. The title was only in his name. Sold the car and hauled it away. And so she was saying that he didn't have the right to do that because she was given temporary possession of the car. The judge in that case ruled that the court, if you look at the code, it does say that the judge can give temporary possession of the house and can order temporary maintenance for the victim or for the children. And then it says, or any other things necessary to achieve safety. I'm paraphrasing the language, but there's kind of this catch-all phrase of, or anything else to achieve safety. And what the judge said is, the law does not specifically allow me to give possession of the car or ownership of the car to this victim. That stuff, all of that stuff has to be dealt with in a divorce proceeding. That's where it should go, and you can't decide, you can't do the mini divorce thing in a domestic abuse protective order. Well, we felt that was pretty significant because even on the petitions where you're asking, there's the check boxes saying temporary possession of the car, and we have often said she can check those off and ask for the things that she needs to have economic security so she can be safe. And essentially this case was completely undermining that, saying no, there's no support for that in the actual code. So we are contesting that, and I am fairly certain that we will win this one because there is that catch-all phrase, and because if the court will allow for temporary possession of the house, and it even specifies it's possession of the house. It isn't granting changes in title. It isn't changing ownership. It's just saying who gets to possess it while the order is in effect. If it's going to do something for something as big as a house, then surely that catch-all phrase applies to lesser possessions like clothing and cars and documents. And we're not talking about ownership and title, which is what's covered in a dissolution. We're simply talking about temporary possession, who gets to use it at the moment while this order is in place. So I think that we will win this one. It's really important that we win this one. Otherwise, otherwise I don't know what to do. So we'll let everybody know when the Supreme Court decides on this. It'll still be a while. Phew, end of slideshow. You mean I actually said everything that I wanted to say? Oh my gosh. Okay, and the only other, all I've got left at the bottom is the temporary orders. When I get them, this is the temporary form order. I have still occasionally seen a judge not using this order and like handwriting an order. And when they do that, they've generally sucked. Again, at Death Review, saw one just recently that was a protective order. It was a permanent order, but it said that he could still call on the phone. So it couldn't be there in person, but could still call on the phone, gave him visitation, gave him access to firearms, and ordered them into joint marriage counseling. And surprise, it didn't work. He shot and killed her anyway. So there are still a few judges that aren't using these, but this is the form that they're supposed to use right now. And as I said, these are all being redone so that they'll be in accordance with the firearms legislation that we got passed. This temporary order, as I said, it does not restrict firearms. Let's take a look at the permanent one. The permanent one, however, the part that you want to make sure is still let's see. Here we go. Number 8. Defendant is advised that the issuance of this protection order may affect his or her right to possess or acquire a firearm or ammunition under federal law. That will be changed to say that it in fact does prevent him from acquiring or possessing a firearm or ammunition under both federal and state law. I have seen that crossed out with black marker. In fact, the order that was issued to Dixie Shanahan's batterer that she eventually killed, a previous protection order, that section was crossed out with big old black marker by the judge, and then he handed him his firearms back. Are there any comments or questions? If you have a specific weird-ass case, like, here's a question. Does the law affect persons that were convicted before the law came into effect? Yes, the firearm ban for conviction of domestic violence, yes, that's retroactive. So it does. And what people don't understand is that I'll answer that before I answer my next question. In terms of a conviction for domestic violence, is that the federal law sets out what is a domestic violence assault, and so if the facts of the case meet the federal definition, it doesn't actually matter what the person was convicted of here. In other words, one of the things that happens here is that the defense attorney and the prosecutor will agree, let's just drop the domestic part off of this and just make it a plain old regular assault charge. The person will still agree to go to the batter's program, they'll still do 2 days in jail, whatever, but it won't be on their record as a domestic assault, and then they'll get to keep their firearms. Well, that actually doesn't work, because if the facts of the case still make it a domestic under the federal definition of a domestic assault, they still do not have access to their firearms, even if they weren't convicted as a domestic assault here in Iowa. They were convicted, let's say, of just a simple misdemeanor assault. And the next question is, does the defendant get restricted on the firearms restrictions do not apply to temporary orders. They only apply after they've had the hearing. So if she's got a temporary order, he does not have to surrender his firearms until they've had the hearing and he gets the permanent order against him. What could happen, let's say that the police showed up at the house and arrested him. She, as a resident of that home, she can ask the police to confiscate the weapons, and they can. They can take them out of there on the spot. Now, he has the right then to go to the court and ask to have them back until such time as there is a permanent restraining order against him, but at least it's out of his hands for a while, right? There's a process he would have to go through to get them back. So no, temporary doesn't kick in the federal legislation. There has to have been the due process there of having them both appear in front of a judge and to be able to present their case. Any other questions? Comments? But I was going to say, if you have some really weird case, he's an astronaut and we can't serve him because he's circling the planet, but we do know where he is. Can we have him? And the threats were made in flag semaphore. I am not the person to answer those questions. I will refer all of those questions to Amber, who is one of our attorneys here at ICADVA. So if you do have some strange case, call Amber or email Amber. It's just Amber Markham, AMBERM, as in Maxine, Amber Markham at icadv.org. Or call here and ask for Amber for your strange, unusual, bizarre, emergency restraining order questions. That's who you should get a hold of. I try and stay up to date on the ins and outs, but here's my disclaimer. But I am not an attorney. I only pretend to be one sometimes. Any other comments or questions? Give you a second to type.
I guess I didn't go back to see in case anybody didn't type a time, but you better know that I couldn't go over the total. There's a couple of them right now coming.
Well, seeing none and hearing none, I have 11:50. So I guess if we'd been here in person, we would have taken a potty break in the middle, and we didn't. So let's just go ahead and end a couple minutes early. And I thank you for coming and spending the morning with me. And, you know, thank you so much for, yes, for asking the question. That is exactly the email address, amberm@icadva.org. Like, duh, Kirsten, you could have just typed that in and sent it out to people. Once again, the handouts for this training, this information is available on our website. If you use the resource pull-down menu under Resource Library, you'll see training manuals for advocates. We do need to get this updated somewhat to comply with the new certification that changed last month, but it'll be almost identical. It'll just be moving some of these around and adding, I think, 3 new topics. But right down here is the handouts. Ta-da! And that's what they look like, so you can download that and peruse it at your leisure. And if you need access to the orders, again, under the Resource tab in the Resource Library, under Legal Documents, you'll see here's the petition. And when the new one comes out, we'll make sure that the updated new one is on there. And then we'll have, this is just the example. Okay, great. Well, thank you all for attending. So have a good morning, do a great job, and ask Amber, harass Amber from this point on if there's any questions. Okay, I'm going to sign everybody off.